Court of the State of Michigan is now in session. The Honorable Seema G. Patel, the Honorable Kathleen A. King, and presiding the Honorable Kirsten Frank Kelly. All persons who have been in the hearing draw near, give attention and shall be heard. The United States of the United States, the State of Michigan, and the Honorable Court, please be seated.
Okay, good morning, everybody. Welcome to the Lansing case call. On behalf of Judge Feeney and Judge Patel, I welcome you. We're looking forward to your arguments, but I want to just make a couple things clear. First of all, we've had a full and fair opportunity to read and review the briefs that have been filed, the exhibits. We're familiar with the background, so when you get up here, do not repeat your brief. Simply focus on what you think is important. We will address all the issues, but we do know your case. So focus on what you think is important. Respond to the other side's argument, bring to our attention any cases that may have come out that may have affected, excuse me, that affected your, I just get all choked up to hear you. Respond to the other parties' arguments and answer any of our questions. Now, if you have any children in your cases, make sure you don't use their names because this is now on YouTube. So use initials or generic like oldest daughter, youngest son, something like that. And if you have a PPO, which I don't think we have today, make sure you don't use initials for them and no addresses. All right. With that, we will call the first case, number 11 on the docket, case number 371065, in-rate petition of Wayne County Treasurer for foreclosure.
Please, the court, Donald Visser, on behalf of the appellant and claimant in this instance, glad to see you, Judge Kelly, get choked up over a tax case.
Well, I knew it was you coming up here. So I was like, oh, thank goodness, Mr. Visser's coming, and I can't wait to hear his argument, but you know I've read your brief.
I do know that, Your Honor. Thank you very much for reminding me as well. I'm not going to repeat the brief, both because I don't think it's worthwhile. I think we covered the issues, and I've had the admonishment now of not repeating. I do want to just bring up a couple of things that I think will put in place. I think this case is now covered by the published case of what I call Brott versus Kent County. It was in Kent County, issued a few months ago, which remanded the case. There's 4 consolidated cases, remanded the cases to the trial court for a determination of whether the notice was adequate. That, of course, is in light of what has been decided in the Bowles case in the Sixth Circuit, acknowledging the difference between the two properties, the real property and the personal property. But in this case, it's particularly acute because illustrated by the facts of this case. This is a claimant that successfully, in the same year, pursued 2 claims in Wayne County Circuit Court for return of remaining proceeds that she had knowledge of. This is the exception because did not have knowledge, therefore a late notice of intention, and that is basically got knowledge through the sale proceeds process, which of course comes after July 1 deadline. So kind of a res ipsa type of situation. When you look at it here, this is not somebody that just missed the deadlines or otherwise, but was successful and did diligently pursue in 2 different instances. So that's why I think In re Brott is or Brott versus Kent County is the appropriate remedy in this particular instance because of the challenge to the notice. I otherwise acknowledge for the issues covered, In re Muskegon controls.
It kind of is.
But also Brott is now a public.
I understand that, but
Is a public case. I do want to also let the court know, just simply in case it figures into delay of your decision or what, the In re Muskegon case is currently on petition for cert to the U.S. Supreme Court. I'll give you just a little history there. I don't know how you read tea leaves up at that level. But it was set originally for a conference in June. It was then kicked over to the September, the long conference, which is September 29. There's another petition out of Michigan, Ketterer versus Manistee County, I think it is. And more recently, a third petition McGee versus Alger County, which is the court just on September 4 ordered responses to be filed.
Well, this opinion will probably be done before the Supreme Court does something, so.
Well, in case you want to know, there's obviously some things pending there because they've now ordered responses. They've now kicked this over again from the September 29 long conference to the October
Well, there have
conference.
been a number of cases that have come out with respect to these kind of issues, so I think we can sort these out. Did you have any questions? Did you?
No,
have
the
anything?
US Supreme Court's busy doing other things right now.
They're really
so-
busy.
Well, I've noticed, it seems like everybody has an emergency petition these days, so,
Everybody's hair is on fire.
All right,
So-
but
so I just let you know that, because I think Colley versus Marshall is one of the first erosions of the authority of In re Muskegon, because Colley versus Marshall says you must have a hearing promptly after you have a forfeiture. In re Muskegon took a forfeiture mechanism, there's no hearing after the forfeiture. So that's, I think that's the kind of the first erosion.
But 78T and 78M all talk about the hearing, that once there's notice sent out and the parties notify the petitioner that they're going to request return of the fees, then the hearing takes place. But that's the way that it was structured. And Ray Muskegon says, okay, that structure that's set up by the legislature is constitutional. So you're saying that somehow the structure is,
I would suggest to the court that that's what Colley really suggested. Colley was issued by the US Supreme Court after In re Muskegon. And it brings into question the legitimacy, I think, of the In re Muskegon result, because it says if there's a forfeiture, you must have a hearing after the forfeiture. You can't do.
Cully deal with a civil forfeiture in a criminal context?
Pardon?
Didn't Cully deal with a civil forfeiture in a criminal context
Well-
from a criminal conviction?
I don't know that it's in a criminal context, but as a result of a forfeiture, as a result of alleged criminal activity. Yes, it does. But I don't think that really makes, when we talk about forfeiture of property, whichever context it comes out of, really doesn't make any difference. I think that type of distinction would suggest that criminals have more protection than civils, the civil forfeitures. I don't think so. At least the way I would see it is that Colley clearly says you got to have a hearing afterwards, and the mechanism of 7018 now I think is put in jeopardy by that ruling, simply because it doesn't allow. It actually has this mechanism that requires you to pre-notice just to preserve a right to a hearing later. And at the time you're supposed to give notice, the property doesn't even exist yet. It doesn't exist until after July 1, when the sale
The
creates
real
a.
property exists though,
Pardon?
right? That's been foreclosed on or is going to be
Oh.
foreclosed on.
But
right?
that makes no difference as to the personal property, which both Bowles in the Sixth Circuit and now in Kent County brought recognize that those are separate and distinct properties based upon Michigan law. One's personal property, the other is real property. And as Raffaelli noted, there are two different takings. One of the fee for the real estate to satisfy the taxes, and then the subsequent taking of the surplus proceeds. So that's why I've really focused in the briefs on my looking at what notice did you give for the taking of the surplus proceeds. And that's where in Kent County, that Brott versus Kent County decision comes in very clearly, says, yeah, we have to look at that separate notice because it's not a unitary process, because you have two distinct pieces of property. We recognize that our statute and our notice here has to meet the Matthews standards in regards to the personal property. And I think where we headed off on In re Muskegon is in the first footnote of In re Muskegon, where the court noted that it wasn't addressing the notice in the due process because of a comment made at the trial court that relative to notice that wasn't therefore preserved as far as that decision. So that's why I think it's not covered, really the notice here. And that's why I think in Ray Muskegon, in Ray King County is the case now that really controls. It has to come back, I think, for a determination as to the adequacy of notice within the context of what's required under
All
78T.
right. Well, I think we understand that.
Okay.
All right. You've got some time for rebuttal.
Thank you very much, Your Honor.
Good morning, Ted Seitz on behalf of the FLE Wayne County Treasurer. Just a couple of points to address some of Mr. Visser's arguments that he's raised today. First, I mean, clearly, In re Muskegon continues to govern this case, and I think as this court mentioned a couple days ago in the Lake County opinion, it's unpublished, number 368740 is the case number. I mean, this is an area that's becoming increasingly well settled. And as far as the notice issues, I mean, there was more than adequate notice. And as far as these kind of constitutional notice issues or other items that he
It's not going
mentioned.
to be addressed here. If you those, either the Supreme Court of the
Right.
United States of America or
Right.
the state of Michigan
Right.
is going to have to deal with those.
Right. And in the meantime, and we didn't file a supplement on this case, but the Sixth Circuit has addressed 78T, its constitutionality, its notice provisions in a case called Howard versus Macomb County. It's a published decision, 133 F 4th 566.
One more time.
133
F4.
F 4th 566. It came out in March of this year, opinion authored by Chief Judge Sutton of the Sixth Circuit, who actually is an expert on state constitutions and their interplay with federal takings and other things. And so he goes through our statute.
So if you're going to, was that in your brief?
It wasn't,
Yeah.
the district
See,
court
when
case
it's
was.
not in your brief, you're supposed to bring a copy of that if you're going to refer to it. That's kind of in the rule.
Yeah, I apologize, Your
Yeah,
Honor.
so like, I don't know what you're talking about because I haven't read that case.
Yeah,
so-
we mentioned the
Well, that's
district.
okay.
No, I'm sorry, I apologize. We mentioned the district court case. But you're right. In preparing for this, I realized we never filed a supplemental
Right.
authority, the Sixth Circuit decision.
So basically, you're just saying the Muskegon case kind of covers
It
this.
does cover it. The Sixth Circuit's affirmed that as well, basically looking at our statute and the notice provisions, and they do not feel that there needs to be a hearing right after forfeiture. I think in the Howard decision, again, you'll see Judge Sutton go through all the notices that people get and the timing of hearings and things like that, and finding it more than adequate, including support for the 5%, recovery fee. So unless the court has any other questions, and I do apologize about not filing a supplemental authority.
You know that.
But otherwise
But yeah, I think it's been briefed really well. I think it's pretty straightforward.
Yeah.
The issues that you're really raising are probably not going to be decided here.
yeah. And he's right. I mean, there are petitions pending in the
There are,
United States
yeah.
Supreme Court, and there's
Yeah.
more than what Mr. Visser mentioned. I think Howard has a cert petition probably coming. There's a couple others that are out there too. So I think we're going to continue to see the
It's
cert
bubbling.
petitions being
It's-
filed.
Although like you said in the beginning, our oral argument is becoming more and more settled.
It really is. It really is, Your Honor.
All right, well, thank you very much.
Thank you.
Do you have any rebuttal?
I do, just very shortly.
I knew you would.
You guessed it.
I did.
Just a couple of things. First of all, again, just to emphasize where the distinction is between real and personal property. This comes out of People versus Fox. It says, Michigan recognizes that real property and personal property aren't just different, they're mutually exclusive. That's also cited in the Bowles decision. And then finally, I'd like to quickly respond to Brother Counsel's reference to Howard. I would encourage the court to read the Howard decision, because the Howard decision is decided solely on the takings basis. And in part, I don't remember what page it is, but it's in the middle of the decision. The court notes there is no due process question involved in this case. If there would have, if the appellant wished to have due process, it should have brought so in a claim in the district court. So it very clearly goes totally outside the due process, and that's really what I'm here arguing. So Howard, it was a disadvantageous decision to the claimant in that particular case, but it was solely outside of due process. And the court was very specific there to note that that should have been brought up and was not being included. So I would encourage you to read the decision, because I think it starts to show what's happening in the other circuit courts, I mean appellate courts, as this is moving along and we start focusing on certain things, just like like the court did in Brott versus Kent County, looking at was there notice, what sufficient to meet Matthew's test. And that's really, it's not here. And I think, again, the proof is in the pudding, because this claimant was successful on 2 claims, brought them timely, and wasn't aware of this one. So there's a failure of the notice in this instance.
I think we understand. Thank you. Case will be submitted. Number 12 on the docket, case number 370785, in re petition Mount Plum County Treasurer for foreclosure. Very taxing day. No, you don't.
I think they could say.
I think you,
Yeah.
yeah, I think you're fine. Actually, I was gonna say, we should probably just call both of them because you just talked, right? You know? All right, go
This
ahead.
is so much more fun to do it
It
this
is fun.
way.
May it please the court, Ted Seitz appearing on behalf of the appellant in this case, the Montcalm County Treasurer. This case presents a few novel issues dealing with a few items, including strict compliance with 70AT on a situation I don't think this court has addressed yet.
Oh, I mean, if there's strict compliance, which I think is made clear through Muskegon. right?
It is, Your Honor, but here we have a situation where we have competing claimants, right?
Well, but Comerica is not similarly situated, I would say, as opposed to the Joneses and the
Rivera.
thank you, and the Riveras. Yes, Mr. Rivera.
I correct you. I agree with you, Your Honor. But I think that the treasurers and the circuit court judges would like some clarity on a situation where someone timely files a notice of intent, but they do not timely file the motion. And this is becoming more important because, as this court is aware from the Schaefer case, with these retroactive claims that are going back 6 years, we had, notice of intents filed by March 31st. There are now motions that must be filed in those retroactive cases by October 1st. So, query those situations that treasurers and circuit courts will still be dealing with, which is, okay, someone filed the notice of intent, but they filed the motion late, and yet are still coming to a hearing, especially when you have, competing claimants. But I do think that would, it may seem like, I agree with Your Honor, under In re Muskegon, as, the circuit court judge, Judge Krieger, picked up on it. And Judge Krieger, she's been handling foreclosure matters for 15 years. She's an excellent judge. Her analysis, I think, is great, honestly, even though I'm appealing her decision in part, including the reconsideration motion. But I do think that an opinion from this court that just makes that clear would be helpful, because I suspect if there isn't a decision, we're going to have some appeals coming up from this retroactive process, especially saying, wait a second, I timely filed my notice of intent to claim by March 31st, and I was just a few days late with the motion, or, hey, I never really got some sort of notice that there was surplus proceeds. And so that's why I'm late. So that's why I do think there needs to be some sort of clarity. And I think that's also useful in the situation that we have here with competing claimants. Because as Judge Krieger mentions, if someone does not file their motion timely, then they really cannot be considered a claimant under 78T, which then that, for this case with the competing claimants of Comerica, that kind of cascades into, how does the judge then allocate surplus proceeds, acknowledging that Comerica certainly had a mortgage interest. They had a judgment lien in this case. And of course, as came out in our argument for the treasurer was, well, maybe this is a situation where the unjust enrichment clause in 78T should be applied, which is another area that I think treasurers and circuit judges could use some clarity on.
Well,
Where
did we just get some clarity on that with the, oh, what was it, the one that, the case that just came out, Chippewa County?
Yep.
That one just talked about the unjust enrichment. And, Comerica has other, they have a way to go about collecting their money, because the Joneses weren't even the ones who took out the loan, right? It
Right.
was like a home improvement loan. So it went from the Joneses to the other
Yes,
people who got the
yes.
loan, and they transferred it back to the Joneses, who then got the judgment against them
Yes.
and everything else. So
Yes.
Comerica is not like out completely. It's not like they've lost. They can just collect once the proceeds are paid to the Joneses.
Yes.
So I don't see how unjust enrichment
Yeah, I do.
works here.
I
And
don't
it-
either. It's not even,
And I do think that with this recent opinion, and the opinion doesn't go into the exact situation we have here. It's more on a property by property basis kind of analysis. But I agree that
who's unjustly enriched?
here it would just be at most the Joneses,
Yeah, but they
correct?
still have a judgment against them.
They
so
still have
they're
a
not
judgment against them.
unjustly
Yeah.
enriched.
Which again,
What if the Joneses' mom came in and said, okay, I'm gonna pay off your judgment, and Comerica's, who's unjustly enriched?
Yeah, they're made whole.
Yeah.
Yeah. I mean, I understand that, but I do think that the treasurers and circuit courts do need some clarity on this, because at times they're having, multiple claimants, or they have one claimant, right? But the claimant discloses, I have a mortgage, for this amount, and they're going to have rights under this. They haven't filed a claim. And so I do think that circuit courts are struggling with, do I factor that in? That these people who make the claim, aren't entitled to the full amount of surplus proceeds because I have this mortgage interest in here, and they may not have filed a
So you
claim.
want the money to go to Comerica even though?
No,
Yeah,
no.
you want to keep them.
No, that's not right. No, I
That's
think,
what it is.
No.
Because if
No.
Comerica doesn't get the money, you get to keep the
no,
money.
the treasurer doesn't
Listen,
want to play, the treasurers
I
don't want to play sides. They really don't. And the circuit courts don't
Would you put it
either.
into escrow?
We did that at first, I believe. There was an
I
order.
couldn't remember.
And I do think that Judge Krieger, in her reconsideration order, makes a valid point on the best path. And I think Judge Feeney talks about this, which is Comerica would still have the right and possibility
Well,
to
but
collect
how-
on the surplus
how's
proceeds
that
after.
your Job to protect Comerica.
It's not. I'm not,
I
and we're
know-
not, we're
I
not
know.
trying to, but I think
It
that,
sure seems like you just don't want the Joneses to get the money, so you're just like, well, let's throw a bunch of torts against the wall and see if it sticks.
no, that's,
You don't have good facts on this one.
well, I agree, but I think what it was left with the treasurer, because they administer this act,
Yeah.
right? And the circuit judge, I mean, she struggled with this. What do I have when I have multiple claimants? One filed this notice of intent, but they didn't file the motion. They filed it late. So what do I do? How do I allocate that? And that's why we wanted the judge to say, okay, there's this unjust enrichment piece in here. Does this apply? And I do think that the, opinion issued earlier this week does provide some clarity, because it does kind of give the court a sense of what the unjust enrichment kind of clause is meant for, which appears to be, federal, state, local, tax liens and other things that should be applied to surplus proceeds, irrespective if those people make a claim, right? And the other place that the treasurers are seeing this and circuit courts is in this 78T retroactive process with restitution. So court ordered restitution orders in the circuit courts that, maybe the prosecutor or the state or the federal government didn't file a claim, but are they supposed to, somehow allocate those funds, or they
No,
decide that?
No,
Yeah.
I think we need to make sure that the trial courts understand that they don't have to do that math. They just have to decide who gets the surplus proceeds.
That's it.
And then the mortgage holder will come in and say, oh, guess what? You got this money. I want money from you. I'm going to get a judgment against you. It's the same thing with like child support. I mean, thank God that when people aren't paying their child support, the front of the court gets to come in and
Yep.
take whatever, tax return they're getting. But it's the same sort of thing here. It doesn't mean that the IRS has to make the decision. It just means the IRS pays the money and then they come and say, whoop, that money comes to us. It's the same thing here for Comerica and all the people. That's why I think that the whole point that the Joneses didn't mention Comerica in their application can't defeat the Joneses receiving it, because there's nothing in the act that says if you don't write, this is not no fault.
Right,
This is not
Right.
no fault.
right.
And just because they leave the name out doesn't mean that somehow they have either committed fraud or they have lost their ability to get the surplus proceeds. Because again, if they get the money, then Comerica is gonna go and say.
They
"I
could, Your
want
Honor,
that
or they
money
may
back."
not, but that's
Yes.
their opportunity to do
Correct.
that. And I do think that, and it may seem odd for me to be advocating this, but the treasurer did not want to just keep the money for herself. Treasurers do not want to do that. What they really want is some sort of clarity, because they're the ones that are getting these claims in. They're the ones that are having to say, okay, I got this claim for this, I got this claim for that, for this property. What am I supposed to do with this? Who am I supposed to give it to? And if I give it, or I advocate, or I say yes, or the court puts it to this particular party, am I going to somehow get sued again by the other claimant who, and
But that's why then the treasurer has to be upfront
Yeah.
and trying to recover, a bunch of money for post judgment hearing attorney's fees is difficult, because I'm not sure if that's permitted under the statute.
yeah, and I understand that too, Your Honor, kind of jumping to that issue as well.
Sorry, Didn't mean to segue. into
No,
that.
you're right. That's,
It's just
that's,
tied
that's
into
a good
It's the
segue.
other one.
Yeah, that's a
We're
good
kinda
segue.
Finished with that argument. So
Yeah.
go ahead with. the attorney fees.
No, I mean, I think segueing to that, if the court wants to, I think that again, Judge Krieger, I think analysis is pretty strong in that area, both in her reconsideration motion and otherwise. Again, the treasurer just wants, and treasurers just want clarity. And I think that Judge Krieger in her reconsideration order kind of puts that type of funds within the 5%, recovery fee. And I think that that's fair reading of the statute. But again, I think the treasurers kind of, they want, in counties, they want some sort of clarity on that. What can they really, get reimbursed for? Because they are, I mean, as this court sees, they have actions that they're defending on the constitutionality of the statute, all over the state of Michigan in federal court and otherwise. The people, they make claims, but they don't really make a claim. They're saying, well, this act is unconstitutional. So I kind of want to claim, but, I want it to be unconstitutional too. And so the treasurer is the one on the ground that has to deal with that. So I do think it's probably a fair reading, because the statute's, I think, a little ambiguous on that and what it means, the cost for administrating the act. And so I do agree with Judge Krieger that a fair reading would be that, okay, those are costs that you get as part of probably the 5% recovery fee, along with kind of the sale of the property and other things, the sales commission, that's probably built into that. So,
And like I said, it's difficult, because I think that the one thing, the costs were, they're like $250. And
Yeah.
then there was $22,000 just as a flat fee. And, for those of us who had to deal with attorney's fees and
Yeah.
Smith versus Corey,
Yeah.
if I don't see a breakdown,
Yeah.
it didn't happen.
Yeah.
So,
and that's a fair point again. I mean, Judge Krieger was right. I mean, in this case, certainly the treasurer could have done a better job of tracking her costs and fees. She just didn't do it. But, I do think on the fee point that I think it's a fair reading of the statute. If this court were to say, yeah, maybe there's no specific language that entitles you to attorney's fees, and that is built into at most the 5%. I do think that would be something that the treasurers and the judges would welcome. Again, clarity, because they're getting this on the front lines. They're seeing more and more of these, obviously, with the retroactive piece. So they have to make these decisions on, okay, who gets what have they presented me with? What do the forms look like? Did they hit the time right? All those decisions. And so I think to continue to provide clarity, whether it's on timely filing the motion, whether it's on what needs to be in the form or not, those types of things would help a lot. So I appreciate the court's time. Unless they have other questions, I'll sit down.
Thank you very
Yeah,
much.
thank
It's a really interesting case. Go ahead.
For the record, if you please, the court, Donald Visser again on behalf of the appellee claimant in this particular instance. Probably will try again with the court's admonition that you've read the briefs and everything else, not try to repeat that, just to respond to a couple comments of brother counsel at this point. Relative to liking clarity, I think that clarity has been pretty well achieved, at least through unpublished decisions. The McGee versus Alger and the Joseph versus Irons counties decisions, which were cases that I brought relative to substantial compliance, where you missed the deadline by one day. No, you didn't send it by the appropriate mail. No. So I think the court has basically established that you can't come in the back door not having timely filed a motion and still be a claimant in this particular case. And we would like some clarity as well, because I have evidenced in representing claimants, not only this case, but also in Macomb County, where the treasurer or its counsel actually sought out people who were in the chain of title to file a late claim. And that's pretty onerous as far as I am concerned, and troublesome. And so I would like to, make it clear that doing that simply is not going to open the door for some type of discussion. I think the parameter of what the trial courts have is pretty well defined in subsection 9 of 78T. And the treasurer talks in this particular instance about its involvement and what information it has to provide. Well, that information is pretty well established in subsection 3 of 78T of what information is to provide. And then after that, its total involvement is protection of the 5%. As far as this broader range of some type of worldwide justice, equalizing everybody's claim, that's no place in the act. But Tyler versus Hennepin County pretty well rejected that, because in that case, the county raised the issue, well, she had a mortgage on it. And the Supreme Court's response was, that doesn't matter, because if she gets the money back, she still has to pay the obligation. So it's not like, well, she doesn't get her money back and she continues to have the obligation. It's got to go to one of those places. As far, Judge Feeney, you've hit the nail right on the head relative to enforcement. I have other cases, and I have quite a few claims throughout, where the front of the court has filed claims based upon the recovery. We get the claims at our office. I have another case out of Kalamazoo County where the creditor has basically filed a garnishment. So the creditors are covered. In this particular instance, I'm suggesting that there is no creditor. I think you've seen that from the standpoint. Co-America is not owed anything. I see in the reply to the court suggesting that the issue of a lien was raised. I would suggest to the court that the issue wasn't preserved. As acknowledged in the reply brief, that was raised in a motion for reconsideration. I can give a number of cases where this court, his precedent on the fact that issues raised in a motion for reconsideration are not preserved for the record. For instance, the Department of Environmental Quality versus Morley, 314 Mishap at 306, the 2015 case is one of those cases. If you wait until the motion for reconsideration.
We're familiar with that.
Yeah, so
concept.
and the problem with the lien that they talk about there, it was a lien it's not in the appendix. It's not for you to see. It was a lien that was filed in 2012, a notice of judgment lien. It expires on its face as well as by statute after 5 years. It hasn't, the reason it's not considered and it's not in the appendix, it is simply, it's just a red herring as far as this is concerned. So from my standpoint, I'd like to probably address, just make crystal clear my position on the attorney fees, because I think subsequent assessment of attorney fees. And I think it's a purely mathematical formula. Now, I tend to go there because that's my undergraduate degree, and I see things in those types of fashions. But subsection 12B makes the determination of remaining proceeds, a summation of three different elements: the minimum bid, then other fees, and I'll come back to that, and then finally the 5%. So the minimum bid, we know what that is. That's defined by 78M. And you go there to define what the minimum bid is. Then, and that includes the phrase that Brother Counsel has raised, and that is fees regarding the administration of the act. Now, of course, when I see fees for being assessing of fees and so forth, I'm saying, okay, but you also have to get credit for what you receive, because that's what's required under the distinct statement clause of the Constitution, is that if you collect your 4% administrative expense, your $175 fee under the act, you have to apply those to your expenses. And I don't see any of that having occurred in this particular context. But I don't think this court has to get that deep into the weeds, because when you look at the definition, subsection B2, it says all other fees and expenses. Now we got the base of the minimum bid, which would include attorney fees up to the point of sale. And then it says all other fees and expenses incurred by the foreclosing governmental unit pursuant to section 78M. And now in connection with what? The forfeiture, foreclosure, sale, maintenance, repair, and remediation of the property. Now, the property here refers solely to the foreclosed real property, not the administration of the personal property. But there's nothing in there about administration of the act. So now when we get to the formula under 78T, unlike 78M, which references for the minimum bid administration of the act, 78T does not allow you to pull back into administration of the act any of those expenses, nor does it mention anything in this formula about attorney fees. It's solely forfeiture, foreclosure, sale, maintenance, repair, and remediation of the property, all of which occur prior to the sale. There is nothing in that formula under 78T that allows anybody to jump back into something under 78M, even if it was previously omitted in the computation of the minimum bid. Because you start with the minimum bid, that's a set number, ready to defined. Okay. So that's, from my standpoint, I think the Chippewa County recent decision provides guidance in this regard. It doesn't allow you to expand beyond what's there. It says, this is talking about unjust enrichment, and then it lists a number of things that might fall within unjust enrichment. In our definition of remaining proceeds, we have a pretty well-defined set of what additional expenses you can add, and it doesn't include attorney fees, and it doesn't include administration. So I think the guidance of Chippewa on this issue should be appropriate, should be utilized here as well.
Thank you.
I don't know if there's any other questions.
Thank you.
Thank you so much for
Your
your time.
rebuttal?
Just real quick. I think coming out of this case, like I mentioned, the useful holding for guidance for treasurers and circuit courts would be that if you don't hit the time frame for filing a notice of intent to claim or the motion for claim, you don't have the ability to then make a claim. It can be considered a claimant under the act. So that's kind of building on the In re Muskegon analysis. And I think the other point of that would be that circuit courts and treasurers don't have to factor in another potential claimant, lien holder, other things if that particular entity does not file a notice of intent to claim and a motion to claim. I mean, basically all the court has in front of it is who made the claim. They don't have to think like, well, you know what, these other parties may have an interest. They may have a mortgage that I'm aware of, but they didn't file a claim. So I don't need to factor them in, including as to any unjust enrichment analysis. I think just those two pieces would provide courts as they deal with more and more of these claims with quite a bit of clarity that would be helpful.
Thank you very much. That was a very interesting case. Nice briefing, both of you. Case will be submitted. Number 13 on the docket, case number 371043, estate of Michael Schlichter versus Kaneki.
The other attorney has not yet checked in.
Well, the case is called. Did he or she call?
Do you have any messages or
No,
anything else?
okay.
And
just
it's
go ahead.
already
We'll have it.
10:44.
Yeah, it's 10:44. I called it. Go ahead. Put your appearance on the record.
Good morning, Your Honors. May it please the court, Paige Batchelder on behalf of the appellee, defendant Frederick Kaneki in this
Argument
case.
just got easier, right? Do you have anything to add other than your brief?
I would rely heavily on my brief. I think really, I know you said to stress the most important issue, and I really wanted to just stress to the court that the appellant's brief brought up some time and distance measurements that were complete guesses. I use words like likely, approximately, no expert to support that. That was strictly done at, and it was news, new information to me that was brought forward in their brief. And I just wanted to stress that that does not create a question of fact in this case. We have testimony, evidence supporting that this all happened very suddenly. And we would rely also on the estate of Homerick case that was unpublished and decided by this court, finding that there was a sudden emergency in that case. And we also had a witness that was in a different vantage point of the accident, which is similar to here with our witnesses in this case. So all in all, our evidence really does support there's no question of fact, and I just wanted to stress that to the court. Any
It's not just a question of fact, it's a question of material fact.
Correct.
Okay, thank you. Do you have anything?
All right,
Thank you very
Thank you
much.
very much.
Easier argument.
Yeah.
Case will be submitted. Number 14 on the docket, case number 372600, Urban Investment Company versus Arbor Hills Landfill.
Good morning, Your Honors. My name is Sarah Reisner, and I'm appearing on behalf of the appellants, the Urban family. I know
You
Your
can
Honor.
adjust that podium too, if you want.
Oh,
I'm pretty
that
sure
would be
this is
really
the one
nice
you
because I
can-
feel like I'm very
Yeah, but
short
you know
on
something?
this.
I don't
Oh, there
know
we
how
go.
There you go.
There
My
you go.
apologies. Thank you.
No, it's the only one we have that you can adjust because I'm tall, you can't tell. But, and I think it's fabulous and I wish that the other courtrooms had
Wait,
it.
Detroit
So-
does.
What?
Doesn't Detroit go up and down?
I'm not,
No,
no,
I didn't.
no, this is the only one. So like I said.
You learn something new every day.
Thank you. I came up here and thought to myself, wow, I feel so short.
Are you comfortable now? I mean, you got it where you want it now?
Yes,
Okay.
yes, thank you.
Perfect. All right, go ahead.
I know Your Honor said that you had reviewed the briefing, and I don't want to repeat all the points in that, obviously, but as you can imagine, the situation's been pretty devastating to my clients. So I want to just sort of emphasize four main points that I think are important in this appeal. The first being that the trial court shouldn't have granted the landfill's motion in the first place because the landfill didn't present admissible evidence that the central basis of their claim that a 500-year storm occurred, they didn't present admissible evidence of that. Second, the trial court and the landfill's analysis on intervening causation just doesn't align with Michigan law. And that's important because the third point is that there are obvious fact disputes on causation here, and my client should have had the opportunity to conduct discovery before the motion was granted. And finally, I want to briefly touch on the issue of the trespass claim. To the first point, Your Honors, the central basis of the landfill's underlying argument before the trial court was that a 500-year storm had occurred, and that because a 500-year storm had occurred and it's statistically improbable means they can't possibly be liable for flooding my client's property with 3 feet of toxic sludge and water. But the problem is that they didn't actually present admissible evidence that a 500-year storm had occurred. Specifically, they claim that there was nearly 5 inches of rain that fell on the subject properties. And they presented an article from MLive, and that was the only basis that
But it wasn't at where the location was. I mean, I live in Rockford, which is outside of Grand Rapids, and something can happen in Grand Rapids that's not happening in Rockford, even though we're not there. Do you know what I mean? And
that.
By
Sorry.
doing an MLive article that it happened in one location as opposed to the subject location doesn't really help you.
I agree absolutely, Your Honor. That MLive article relied on data from the Willow Run Airport, which is about 15 miles away from where these properties are. We pulled data from the closest National Weather Service station we could find to the properties, and that said that across the entire day that this flood occurred, there was only 1.15 inches of rain. So I think there's an obvious fact dispute there over how much rain actually fell in the relevant area. And you know, that's setting aside that we would argue the MLive article wasn't admissible evidence in the first place that should have been considered. Now the landfill in their response brief points to this 2-page affidavit that they submitted from a proffered meteorologist named Mr. Callbaum. And to be clear, the trial court didn't mention and didn't appear to rely on that affidavit at all. And it was proper in doing so for 2 reasons. First, actually for 3 reasons. First, because the affidavit wasn't admissible in order to rely on expert testimony in a C-10 motion. The proffering party needs to show that it meets the standards of 702. And this affidavit didn't explain how Mr. Callbaum came to his conclusions. Second, the data that Mr. Callbaum relies on, he says he doesn't say specifically what data he used, but he says he pulls data from 3 sources. He came to the conclusion based on that data that over a 3-hour period between 1 and 6 a.m. on August 24th, there was.
No deposition was taken, right?
Correct, Your Honor.
There was no discovery yet, right?
This was a
Correct.
motion in lieu of
I-
an answer, right?
Right.
Yeah, and that was going to be my.
So, well, I know that's your point. I mean, you can't take if you have an affidavit, that might be the gold standard in affidavits, but unless you can test it. So it doesn't, anyway, so I don't think you have to argue that point.
And Your Honor, that was exactly my third point, and so that was what I was going to get to next. That this is a
See, we
C-10,
read your stuff.
right?
We do.
That was filed before discovery had even begun. And it even if the affidavit was admissible and the data was consistent with it, you know, my clients had a right to take discovery on the affidavit.
I think I just said.
Yes. And
Anything further?
Your Honor, just quickly to the second point on intervening causation. So the trial courts and the landfill's analysis here is basically because a storm occurred and a 500-year storm, setting aside the discovery issue and the admissibility issue, is unforeseeable. It means that it automatically cuts them off from all liability. And that's just not how Michigan law on causation works, right? So there's 2 intertwined legal concepts that are important. The first being that the Taylor versus Wyleth Lab and the Comstock versus General Motors proposition that if a subsequent event after a negligent act occurs and the negligent act is still going on and the injury is no different than what one would expect to occur as a result of the negligence, then it's not really an intervening cause. And the second is the foreseeability analysis with, Monning versus V. Alfano and Williams v. Jones, right? That scope of risk test, that if the event and the injury are the reason why it is negligent to engage in that action in the first place, it's not really an intervening cause. And there's that great analogy or hypothetical from the restatement of torts in our brief that just fits this scenario 1-to-1, right?
Which we read.
Right.
In your brief.
Correct.
When you filed it.
Correct.
Okay.
Yes.
So is there anything in addition that's not in your brief? Because it's really brief. I mean, there's responses and,
Your Honor, I just to address quickly the points in the landfill's response brief, right? That essentially their argument is, well, the urban family can't show precisely how the landfill failed to maintain its system. It hasn't specifically proven that chain of
Well,
causation.
how can you
And
do that if you don't have discovery?
that's what I was just about to say, Your Honor.
how about it?
But that brings us back to that Powell versus Murphy standard. And just to briefly conclude, that the trespass issue, to be clear, this is not a case about natural servitude.
You know, you have time for rebuttal.
Yeah. Okay. Thank you.
Good morning, Your Honors. May it please the court, Hillary Ballantyne on behalf of defendant appellee. Seated with me at council table is Roderick Fracassi, also of my firm. Your Honors, we respectfully request that this court affirm the trial court's grant of summary
You know, I
disposition.
tell you, I have a really serious problem with this case, that
Okay.
this was granted before any discovery at all. You know, and it's almost like, well, you focus on a unlikely event, a 500-year storm, but really when you talk about the cause of action is negligence in the maintenance or whatever of, you know, the urban, that should have been able to withstand a 500-year storm, or getting discoveries like, well, you couldn't even done a 50-year storm. You know, I mean, there's no discovery. There's nothing in here. Then you get this affidavit. It's like, well, can you take that at its word, or don't you get to test that? I mean,
Well, I understand. I
Yeah.
appreciate that no discovery has been completed, but I would say this is different than the type of case where a complaint is filed, a motion for summary is filed in lieu of an answer before discovery has even begun. When plaintiff filed their complaint, they filed their complaint on July 1st of 2024, almost a year after the flood occurred. Within that time, they had hired an environmental company to do testing. They had gotten affidavits. They had done a fair amount of quote discovery on their own before they even filed the complaint. And they filed with the complaint, you know, tens of pages of documents of environmental testing. So I would say, Your Honor, and I appreciate Your Honor's concern, but this is different than the typical complaint filed without anything, without any discovery, and then a motion filed in lieu of an answer. And Your Honor, with respect to the affidavit, it is admissible, and he did say what he relied upon and that it met the standards of MRE.
I'm not saying that. I'm just saying
Okay.
that there's no deposition, there's no testing of the affidavit conclusions or anything like that.
Well, Your Honor,
Ability
they,
to cross-examine
Yeah,
the
that's a
witness.
better way to say
Yeah.
it.
right, but they haven't indicated in their briefing or here today what further discovery might entail. They point to documentation that says, oh, well, only 1.15 inches of rain fell. And they attach that in response to our MST. So they came forward with evidence. And Your Honor, if they're going to say that our expert affidavit is unreliable, then certainly what they're attaching to their response at their appendix, page 364 from the National Weather Service indicates it's inherently unreliable. It says, these data are quality controlled and may not be identical to the original observations.
Well, I think I disagree with both of you in terms of the admissibility of the affidavit because the way I understand it, on a summary disposition motion, it's not admissible evidence, but evidence that could be admissible at the time of trial. So affidavits are considered. But I do have a problem with the posture of this case. This was a motion in lieu of an answer. Because you've attached things, it's turned into a C-10 motion. But that's, I mean, regardless of what due diligence plaintiffs may have done to attach to their complaint to give, you know, much more than just notice pleading, there's a reason we have a process in the courts. And so I don't, can you give me a justification for why we should do an end run around that process and decide this on a summary basis?
Sure, Your Honor. What I would say first is that we filed as a C8 and a C10. C8 as to trespass claim, which I do ask that this court affirm the trial court's ruling with respect to trespass, not to digress, but they have pled nothing that there was an intentional intrusion upon the land. And two, with respect to the C10, there are many cases, and I've cited them in my brief, that say a motion in lieu of an answer or before discovery has been completed is proper if there is no indication from the plaintiff that what further discovery would entail. And as I said, this isn't the typical case where they've attached nothing. They did environmental testing, they got affidavits, they got pictures, they basically did their discovery. And what have they said today that they would uncover? They've already attempted to introduce evidence that says, no, it wasn't a 4.5 inch of rain in a 3-hour period. It was a 1.15 inch of rain. They could have gotten an expert at this time. They could have offered something. They didn't indicate to the court what further discovery would entail. So I do believe on a summary basis that in this type of case, with this type of event that, that it's appropriate and the trial court's ruling should be affirmed. And while perhaps the trial court shouldn't have relied on the article, the trial court's ruling can be affirmed by anything that's supported by the record. And the information contained within that article was from the Washtenaw County Water Resource Commissioner's records of regularly kept activity, which would be an exclusion under MRE 8036. And it talks about the rare occurrence of this storm and whether there was 1.15 inches of rain or 4.5 inches of rain. Where have they pled that this was foreseeable? And a non-human force, to touch upon plaintiff counsel's argument as to causation, a non-human force can create an intervening cause and be a superseding cause, relieving a defendant of any liability if it's unforeseeable. And they have not pled or shown or said that any further discovery would show that such event was foreseeable. And they talk about, previous violations of leachate, which is a completely different substance. I've learned a lot about landfills and in preparing for this case, more than frankly I ever want to know. But they talk about, what the landfill was required to do. And in that own documentation they cite, it says that they had to make sure that their landfill was retained, that had a stormwater retention system to handle a 25-year storm. And they haven't shown that it met that standard. So even at this early juncture, and I appreciate the court's concern, even at this early juncture, they haven't shown that this is foreseeable in any event. And so based on a lack of causation alone, a lack to plead, and an inability to show what further discovery would prove, we would ask that this court affirm the trial court's grant of negligence. And again, touching on the trespass issue, which was on a C8 basis, and we would ask that this court can affirm on a C8 basis, there was no intentional intrusion. There was nothing pled in the complaint. There was an intentional intrusion.
I get your point on that one. I just have a real problem with the lack of discovery on this one.
I understand.
On that particular count.
I understand.
Right.
Are there any other questions that I can address?
Thank you. Thank you. Rebuttal?
you.
Just very briefly, because it seems like your honors understand our concern about the lack of discovery too, but I just want to be clear. We did point out to the trial court and then in our briefing here that discovery is needed on, for example, the weather of that day and the expert meteorologist that they provided an affidavit from, and that discovery is important on the specific way in which the landfill maintains and upkeeps and constructed their stormwater management system. I mean, we can't possibly know exactly what went wrong with their system because that's entirely in their hands. And that's the entire purpose of discovery. To the second point, to be clear, the foreseeability analysis isn't about whether the probability of a 500-year storm occurring is foreseeable. The foreseeability analysis under the scope of the risk test is whether it's foreseeable that failure to maintain a stormwater management system in general can cause flooding. And we absolutely provided evidence that it was foreseeable that would happen because it's happened in the past. It wasn't just leachate releases. Just a year before this flood occurred, the landfill flooded the other side of the property during a storm. And I also want to point out to your honors, and I understand that this isn't part of the record, but I think that this is important context. After we finished briefing before this court and obviously before the trial court, over the past 6 months, my clients' properties have continued to flood from the landfill.
If it's not on the record, you really can't bring it up.
That's fine, Your Honor. I can move on from that.
Is there anything else?
No, Your Honor. Thank you so much for your consideration today.
Case will be submitted. Did you need to take a break or something? Just keep going? You want to take a break, I guess? Sure. We don't have that many more, do we?
I think we have one more with argument.
Keep going. Yeah. Calling number 15 on the docket, case number 370-615. In Ray, Justin Paul DeReezy, MD. What? Yeah. Mhm. Yeah, well, that's right. That's fine. If you want to take a break, just let me know.
and 16 are it. So. Anybody here for police?
Good morning, Your Honors.
I
Good
know,
morning.
I know. Well, I called the case. They're not here. Go ahead.
Aiden Javilla on behalf of Dr. DeRezi. Try to remember to relower the podium.
I thought Detroit had it too, so.
May it please the court. As you know, Dr. DeRezi has appealed and challenged the Professional Bureau of Licensing's ruling that he committed two separate violations of MCL 333.16221A. Two instances, one at the patient's admission, and the second in failing to supervise physician's assistant DICEA later on. And we've articulated several grounds in our brief for why the court should reverse, but I want to direct the court's attention to two in particular, because I think those are the principal reasons why we should win in this appeal. First, there is no expert that testified in this contested case that the notation they take an issue with of inspection, no ulcers, no rashes, that alone under these circumstances was a breach of the standard of care, a violation of general duty. But Dr. Krisoff's testimony was quite different, and it depended on her belief that no orders were made to protect this gentleman. Those are almost her words exactly.
Dr. DeRizzi said that he inspected the patient, even though the patient came in late in the day, and to say that he observed no skin issues. That's one thing versus he had a very large lesion on his left heel and he had two lesions on his back and his buttocks. So either I thought that the expert testified that either you say, I was not able to inspect the patient because I couldn't turn them, or you say, I inspected the patient and saw nothing. But by saying I inspected the patient and saw nothing, it was like very obvious on the left heel and obvious had they just rolled the patient over. So you can't say that there was no expert testimony with respect to that. I find that difficult.
Oh, no, I'm not saying that Dr. Krisoff didn't testify that he should have done something different. That's not what I'm saying at all. And I would have to concede that there's substantial evidence in the record to support that this is not the right practice, that, or he should have notated it differently. Maybe he should have said, I didn't do a full inspection. There's substantial evidence of that. But the question here is, did he fail to exercise due care toward AH? And this is a process, just like this judicial system we're in here is a process. You can't stop in the middle of the process, okay, at the notation. You have to look beyond that. And I think there's a very interesting story that this court probably hasn't heard and was maybe not apparent from the PFD, but it's in there. What happened was when they initiated this prosecution, Ms. Pappas had done a subpoena to Wellbridge, and her subpoena covered March 15 to March 25. Well, the admission was on March 14. So because she had not subpoenaed the records from that day, she had no idea what the doctor had done to protect the patient. And that information was not given to Dr. Krisoff when she formed her opinion. And when they filed the administrative complaint, you'll see that it depended on an expert. It says in there, based on the expert, here's what they failed to do. And the ALJ rejected every single one of those findings in the complaint. There was nothing in that complaint about the notation itself being the cause for this prosecution. Nothing. So that they didn't find out that they were missing some 25 pages of records until 1 month before the contested case trial. And if you read Dr. Krisoff's testimony, you'll see that she didn't change course at all. I don't know whether they gave her the records or not, but it's as if they didn't. Because if you look at what she says, her ultimate conclusion on how he breached the duty of care, and we block quoted this on page 19 of our brief. She says, basically, he missed the 3 ulcers the AH had upon admission to the facility, which were documented by the nurse on 3/15, who did a total body skin check of this patient. And she documented 2 buttocks wounds and 1 left heel wound. Therefore, he failed to diagnose, and therefore, because he did not diagnose, he was not aware of these wounds. He made no orders to further protect this gentleman or to do wound care of the wounds that existed, which is false. Absolutely false.
And no orders on the 14th,
Yes, there were.
not by him.
Yes, by him. In fact, the ALJ found they were his orders. I can walk you through that real quick. It's in the PFD. If you look on page 49 of the appendix,
Well-
paragraph 11 says, with respect to petitioner's exhibit 9, Dr. DeRezi credibly testified that this is a physician-directed care plan and that he signed off on all of the orders. These orders were his. The ALJ rejected the notion that there's the nurse that signed these orders
But
and
then
the nurse that created the
So,
welfare
so we're
plan.
supposed to expect that he didn't see any skin lesions on the 14th, yet he was the one who ordered skin protection. And then you want to say on the other side, well, he didn't sign off on the PA's notes because that was just a glitch in the system. So I don't think you can have it both ways.
Well, why not? The ALJ found in our favor. The ALJ found in our favor that he signed these orders. So I can have it that way unless the court is willing to reverse the ALJ and say there's no substantial evidence that he signed those orders. I mean, that's what the ALJ's finding is. And it says,
I understand what you're saying, and I guess maybe I'm jumping ahead because your point is though he didn't sign off on what the PA was doing, correct?
well, we have 2 points on the PA issue. I mean, the first one, the most important one is there is no legal duty to supervise, period. It doesn't matter if he signed off on it. And frankly, there's not, the second point is there's not substantial evidence to say what that signature even means. We don't know when that signature arrived on there. We don't know how it arrived on there. Nobody explained how it arrived on there except for Dr. DeRezi. His is the only testimony in the record on that point. The only one. And we have a statute on point that says you cannot just presume that an e-signature is that the e-signature is of that person. You have to, the e-signature only means that it's signed by that person if they acted to put it there. So those are our 2 main points. I think it's the rest of the PFD that I wanted to direct you to in terms of the question about whether he failed to exercise due care are on the next page after the ALJ talks about him signing off on all the orders is the orders. Okay. We have a skin assessment per order. All right. That was on March 14. They didn't have that record when they filed this administrative complaint. There was a keep the skin clean and dry, use lotion on the dry skin, pressure reducing specialty air mattress and protect the skin while in bed. That was specifically one of the things they said he did not do in the administrative complaint. And in fact, it was ordered on March 14, 2019. The nurses weren't even there until the 15th. This patient came in at 10 p.m. Okay. Dr. DeRezi was about to head out the door and they called him back. And it just so happened that he spoke the same language as this patient at the time. And so we talked to him and did this initial assessment. And then he ordered further skin assessment to make sure that the wounds were caught. And he ordered a whole wound care plan for it that included all the things that Dr. Kristoff said he should have done.
So you're saying that he ordered the review
See any lesions.
without saying anything?
No, I'm saying he created the skincare plan based on the nurse's diagnosis.
Which was on the 15th, because the nurse only saw him on the 15th. So
Well-
you keep saying this is all happening on the 14th. He talked to him on the 14th. He found no wounds. The nurse talked to him and saw all the lesions on the 15th. And that's when the plan of care was then developed, correct?
That's when it was implemented. There was a plan of care initially developed and then they revised it. But
Why
it's,
did he
it's the
do a
dates are
plan if he
on,
didn't see any? Why is he doing a plan if he didn't see anything?
well, the patient's a quadriplegic. So he's not going to be able to move. So you need to, I mean, you need to have a wound care plan to make sure that he doesn't develop
So he
wounds
didn't
first
have to
of all.
inspect him anyway.
And then,
right?
and then,
So he never had to inspect him or look at him or do
If-
anything because he's a quadriplegic?
well, no,
I mean,
it's,
your argument's not making any sense here.
okay.
It's just
Dr.
not.
DeResi had no duty to do this assessment himself.
Okay,
Okay, can we agree on that?
no,
because-
but
well-
that's your position.
Well,
Okay,
there's no
let's-
testimony that he
Okay,
did.
well,
And
let's
that-
say your argument is he has no duty. Okay,
And
next.
the ALJ did not rule that he had a duty to do it himself. Did
So
not.
that's an error in the determination.
No, it's not an error. We accept that he does not have that duty.
Okay.
And we
So
agree
what's
with,
the legal error that occurred here? I mean, you're arguing facts.
well, this is a substantial evidence review. So we have to look at whether there is substantial evidence to support the conclusion that the ALJ made. The ALJ found that he had ordered wound care, found that. That's a finding in the PFD, that he ordered the skin assessment and Dr. DeResi ordered the wound care. And I can point you to exactly where that is in the PFD. That's a finding of fact by the ALJ. That is the duty of care that Dr. Krisoff said was missing. And so there is no evidence to support the conclusion that Dr. DeRisi failed to provide the care that was required for this patient,
Well,
for his bed
except he
sores.
didn't inspect the patient.
He doesn't need to. He's got a whole
So you don't have
interdisciplinary
to
team.
inspect the patient, but you can go ahead and do a care plan.
Well, you can do a care plan and modify it, and there are lots of steps that they take for quadriplegics.
I'm going down a rabbit hole.
I-
It just-
yeah,
Yeah, I know.
The point is that the ALJ said he did it.
I know, okay.
And the
I know, I
ALJ
got
found-
sidetracked. I just
The
found
ALJ
it
found,
strange.
the ALJ found that he did that he did exactly what Dr. Krisoff said he did not do. It's in the findings.
Where, what page is that on the PFD?
PFD app 60, where DeResi credibly testified that his orders were part of that night.
No, so, okay, that's the PFD at 60, that's what the ALJ finding. That DeRisi said that he looked
Yes,
at the patient and made determination with respect to skin care.
no, what we're relying on, look, clearly he did not see the bed sores on the inspection, whatever it was that he did. Okay, that's a fact. The question is, did he fail to exercise due care when the patient was admitted? Okay, and our point is that that alone is not sufficient to say that he breached the standard of care in a situation where he ordered a full skin assessment, which the PFD finds he did, and ordered a wound care plan, which the PFD finds he did.
Sounds terrible. Oh, okay.
I think it's important to remember that if this was just about a $10,000 fine and some continuing legal education for him, we would not be here. Okay. This finding can severely damage and ruin a doctor's career. That's what we're talking about. You lose insurance certifications, okay, which makes it extremely difficult to practice when you don't have insurance certifications for Priority Health and Blue Cross.
You know, his testimony though, as he was going through this, you would imagine he might be a little bit more circumspect in his language that he used throughout his testimony. I think excoriating was one of the descriptive words I could use. So I don't know whether his anger or his frustration over the whole circumstance, but somebody who's trying to protect their reputation and the man that you're talking about and all the negative consequences, that did not come through in his testimony. In my humble opinion.
I wasn't there. My colleague was. And I'm happy to have him talk to you about it.
Well, you only have like a minute and
a minute and a half left.
because you don't get your half hour.
But I would not be surprised if he was very frustrated about being brought on a violation for that one notation and it particularly when the administrative complaint said he did not do all these things that in fact he did, and the PFD rejected the idea that he didn't.
Do you want to talk about the PA?
Yeah, the main point there is there is simply no legal duty to supervise the PA, period. The legislature had imposed a duty and it took it away. And nothing about having some e-signature that appears on records produced by Wellbridge, which by the way is not his company. Those are not his records. He is not the one who created that system. There's no evidence that he did. They produced those via subpoena, did not come to him. Okay. That does not, even if that e-signature suggests that at some point he signed that, maybe pursuant to an audit or what have you, 6 months down the road, we don't know. Doesn't have anything to do with care for AH. And that's what the failure to supervise goes to. The failure to exercise due care, including negligent supervision. Okay, first of all. And secondly, it doesn't create a duty to supervise the PA. The PA is entitled to practice without the supervision of the doctor under Michigan law at this point in time.
Okay, you're out of time.
Thank you.
Thank you.
Your
Case will
Honors.
be submitted.
Thank you.
Number 16 on the docket, case number 374073. And I'm going to mispronounce this. Is it Kubler versus Kubler? That's not right.
I said Keebler. but-
Keebler? Is it Keebler? You know,
Good Dutch people, they drop the first vowel and pronounce the second one. I
yeah,
don't think
Judge
Keebler
Feeney
is
told me that
Dutch.
when I came out here, and then I got all confused and I
I'm
forgot what
sorry.
she told me. So it's so nice to see you this morning, though.
It
or
is nice to
this-
see your honors as well. Jordan Naylor Smith on behalf of the appellant mother in this case, who is present here in the courtroom today. I'm not quite as tall as Mr. I always pronounce his name wrong. I just call him by his first name. I'm not quite as tall as Gaten, so I lowered the podium for
Okay.
myself. Very appreciative of your honors granting my motion for oral argument so I could come chat with you this morning. I really only have two main points that I wanted to highlight. The first one being on our ECE argument, which is essentially in a nutshell that the trial court's decision to apply the clear and convincing burden is just not consistent with the trial court's own finding that mother's request would not change the ECE. I believe the law is very clear on that point, that when a trial court finds that a request will not change the ECE, the appropriate burden to apply is preponderance of the evidence.
I'm sorry. If it doesn't change the ECE?
Correct. If a request in a motion to modify custody does not change the ECE, the appropriate burden to apply is the preponderance burden.
But when both the parents have an established custodial environment and you want to do something to change it, then you have to have clear and convincing evidence.
Correct, Your Honor, but my client wasn't asking to change the ECE. She was asking that both parties be awarded legal custody, which would not change the ECE when both parties already had an ECE.
Well, but legal, I mean, we're talking about fairly esoteric things here, right? Okay, because, I mean, this is the third judge who's been on this case. And, dad had sole legal custody, right?
Yes.
And it's one of those circumstances that when you make determinations regarding physical custody and legal custody, I always call legal custody the meat and potatoes of parenting, right? It's where do they go to school, what kind of discipline they receive, what kind of medical treatment they should get and everything else. And then the physical custody, you know, where they spend their time. But I think anytime you're looking at amending legal custody, when it goes from sole to joint, that is going to have a huge impact on that established custodial environment. And you're going to have to prove more because going from joint to sole is a big, huge jump. And I don't think I've ever seen it where you haven't had to have clear and convincing evidence. So I don't see how going from if going from joint to sole is big, how going from sole to joint isn't big. Do you know what I'm saying?
I do, Your Honor, and I can certainly appreciate that. The way that I'm looking at it is the fact that the standard is the same, and all of this court's case law and the case law of this state says that where the ECE doesn't change, we apply the preponderance burden. There's no difference when we're talking about physical or legal custody under the law, the way that it is written and interpreted in this state. That's the argument that I'm making. And I can certainly appreciate your point of view, Judge Feeney, because I do agree that it is meat and potato. It's the meat and potatoes of parenting. It is important decisions. And I think part of the problem in this case, which was the second point that I was going to get to, is that we're dealing with issues that aren't really big issues. We're dealing with every single minute thing that mother wants to do during her parenting time, father is making into a major issue. So I think that by applying the preponderance burden, which would be consistent with the way that the law is interpreted and written in this state, we're recognizing the fact that the decisions that were being brought to the court are not actually the important decisions that are affecting the welfare of the children. And I apologize if that doesn't make any sense as I was saying it. And I think that's also something that Justice Kavanaugh highlighted in her concurrence in the Supreme Court order, which I fully recognize is not binding, but I do think it's very persuasive in this case. And I do also think that the testimony of the GAL is consistent with that as well, in that the GAL did testify, that father would make all of these big issues, make small issues into big problems, is the way that I phrased it. That's really all that I wanted to highlight for your honors this morning. Unless you have any further questions for me, I would reserve the remainder of my time to respond to Mr. Vella's arguments. Thank you.
Good morning. John Vella on behalf of the appellee, Mr. Paul Keebler. And I just filed my appearance strictly for today. I'm the B team to argue this case. Miss Ann Argeroff is the appellate attorney, but could not be here today. So I'm filling in for her. Regarding the ECE, if I may.
Yeah.
Regarding the ECE, I certainly think that there's a different take on this altogether. Now, we know that Mr. Keebler had sole legal custody from the divorce in 2017, that in 2023 that was changed, and there was on paper, joint legal custody for about a year and a half. Now, that is only on paper, and the ECE requires much more than just, hey, they have joint legal custody on paper. Joint legal custody requires the willingness to communicate and cooperate. And I'm citing that from Butler 308, Mishap 201. The ability to cooperate with each other in joint decision-making. And I'm citing Fisher, 118 Mishap at 232 to 233. In addition, when determining whether and with whom a child has an established custodial environment, the focus is on the child's circumstances, not the order or orders that created those circumstances. And that's coming from Hayes v. Hayes 209 Mishap 385, being cited by Lieberman v. Orr 319 Mishap 68. In addition, from Lieberman, the trial court's custody order is irrelevant to determining the children's established custodial environment. And again, citing Hayes, because the focus is always on the child in determining the ECE. The reason why I'm saying that the focus is on the child, and the reason why I'm quoting the case law, that it doesn't matter what's in the order, because in reality, in this case, mother in this case never had the ECE. She never even had it when it pertained to legal custody. There has never been, and it's documented throughout all the trial transcripts and hearings, there's never been a legal decision that these parties have ever made jointly. Every major legal decision came down to either a motion hearing for the court to decide, a GAL to weigh in, and came down to litigation. Not one time could they agree on a joint legal decision. The children, and it's present throughout that entire trial transcript, always look to the father for the support and guidance and everything related to the legal custody issues. They did not look to mother. Mother was not the one signing them up for school or signing them up for doctor's appointments or making decisions. In fact, during that year and a half time frame where on paper there was joint legal custody, there was only one major legal decision to be made between the parties. The children were in therapy, but that was due to therapists selected from prior litigation and from the court. There oldest daughter needed braces. And there was testimony throughout this case, 6 months of our family wizard messages back and forth between father and mother, just trying to decide whether their oldest daughter could get braces. Ultimately, during that 1.5 year time frame in December of 2023, there had to be a motion filed. And the judge had to make the decision on whether the oldest child could get braces or not.
Are you talking the 1.5 years? Is that when Judge Vandenberg had the case?
Yeah, so Judge Vandenberg issued her ruling in July, I believe, of 22, may have been 23. Sorry, I apologize. And for 1.5 years on paper, there was joint legal custody. Half of that did overlap also with Judge O'Brien after Judge Vandenberg recused herself from the case. So that was the main decision that the parties were, had during that 1.5 year time frame. And again, 6 months going through back and forth, our family wizards. Eventually, a motion had to be filed, and Judge O'Brien had to decide, yes, the oldest child should be able to get her braces. So that being said, there was no ECE ever with mother. So the burden is certainly clear and convincing for mother to change the ECE, which was strictly with father, to jointly. And that's why there's a clear and convincing burden. Now, I will say, if you review the entire transcript, even if you were to use a lower burden, it wouldn't matter. She didn't meet it. And the record is just ripe with reasons why these two cannot communicate together to make joint legal decisions regarding the children's best interest. Going back to the trial in this case, there were times where the mother was asked to define something, and she would use the word now. A simple word. I think we all know what now means. And then when impeached on, well, that didn't happen now, it happened months ago, she would change her definition of the word now to mean any time within the past year. She would represent to the court continuously untruthful statements, such as she was late bringing the children to school because of medical appointments, because she had to take the children to medical appointments.
A lot of this is already available to us either through the transcripts and the briefing and everything like that. I think basically what you're saying is you want us to affirm the trial court.
Yes.
Okay.
Can I just touch on just a couple of?
Yeah,
I don't want to.
I mean, you know.
No, I get the cue. If I could just have.
I don't know why you have to keep beating people. Oh, okay. I mean, this isn't helpful.
Okay.
Okay.
As you know, ultimately in this case, the court had to weigh in on every single issue.
As difficult, long-running, complicated case with these parties.
Yes. And
so the judge has to go through all this and listen to the attorneys and listen to the parties and try to fashion an appropriate parenting plan to facilitate or minimize the stress on children. So going through all the things that the mom did bad isn't really helpful here.
I understand. Just two minor points, and then I get the cue. I'll move on. Specifically in regards to parents who get along, to have joint legal custody, they need to be able to communicate with each other. There was one issue where, and it came up at trial, there was 147 violations of the Our Family Wizard order, where mother was required to, both parties were required to respond to each other on Our Family Wizard within 48 hours. And there was 148 violations in a 2-year period, 147 violations in a 2-year period.
Oh, we ought to just strip parental rights for that.
No.
Yeah, we should. Let's do that. This argument, I think, is pretty much concluded.
Okay. Thank you.
Just very briefly, Your Honors, I just wanted to touch on Brother Counsel's argument about the existence of the ECE. The trial court made the finding we're not challenging it. I do think there was evidence that mother was actively involved in the girl's care when the parties were joint legal custodians. And I think that there's evidence that the parties could work together. And all of that is in my briefs. So I would just respectfully request that this case be submitted. Thank you so much.
What's the strongest evidence of the fact that they can participate together? I mean, correct me if I'm wrong. Didn't the court have to make a decision regarding what to do?
That, yes, Your Honor, that did happen. I believe it was during the divorce proceedings, if I'm remembering correctly.
In the 22 years I spent doing this work, these kind of cases are the ones that give you post-traumatic stress disorder because you are so intimately involved with these families. And it's very clear. I tell people when courts make determinations regarding sole legal custody, it's fairly rare that we do that because under the statute and the court rules, you can move to Timbuktu without doing anything other than telling us what your forwarding address is, right? So it's a very difficult decision for a court to have to make. But when you have parties who can't even agree on the name of their child or a year and a half or how many months it was, 6 months, I think it was, to decide if the child's going to get braces or are they going to do soccer or basketball or who's going to take them or who's going to schedule something else on the day that they have a play so they can't go to the play. It's just, the impact on these children is significant. That's why you can't have two people who can't get along have joint legal custody. So give me your best evidence of 3 examples of your best evidence of how these two people can communicate with each other regarding the important issues dealing with their children.
I can't give you 3 specific ones, Your Honor. What I will say is that I think that the testimony of the GAL is extremely helpful in that, in this respect, because I do think the GAL testified that the parties could work together and they did have the ability to do that. So I can.
But that's could indicates to me
Could.
future. I want to see some evidence that right now they can, and I'm not seeing that on the record in front of us.
And everything's couched in terms of how awful the other parent is, not what's good for the children. And I apologize for cutting you off. I probably shouldn't have done that, but this has been going on way too long. And I don't know how you can fix some of this damage, but this is, family law is a continuum. So this court, even those 2 or 3 judges, right? Is familiar with this case. It's going to go on, but until these parties decide not to hate each other and only want to love their children, we're stuck with the record that we have.
Then I understand that, Your Honors. Again,
Well,
thank you so much.
The case will be submitted, and I do apologize.
Nope.
And I'm sorry about that. And say hi to Ann.
Thank you very much for your time.
Thank you, Your Honors.
Thank you.
Okay, calling case number 17 on the docket, case number 373-328, in re DEAIBES minor. Case will be submitted on the briefs. Number 18 on the docket, case number 373-334, in re Schuldish minor. It's SCHUDLICH, which I mispronounced. That case will be submitted on the briefs. 19 on the docket, case number 375-047, in re McKay minor. The case will be submitted on our briefs. That concludes the Lansing case call. Thank you.